Members, that concludes the new bills today. We do have witnesses, but we are going to lose quorum at or around 10 a.m. and we are waiting for potentially Senator Campbell and Senator Powell to come back so that we may vote starting before what I had said earlier, which was 10 after 10. So while we're waiting, we are going to take public testimony on House Bill 1504. The chair calls Sheila Hemphill, Texas Right to Know. Sheila Hemphill here. Please come forward and we'll take another witness. No, there's no others. I know that we have a number of people wanting to testify on a couple of other bills. If we don't finish before we go to the floor, we will come back and take public testimony, but we'll do our very best that we can. If you would, state your name for the record and who you're with, and you'll have 2 minutes to testify.
Thank you, Madam Chair. My name is Sheila Hemphill with Texas Right to Know, and I'm opposing House Bill 1504. The reason for the opposition deals with the recommendations that were communicated during the Sunset Commission, which are essential to help rein in what is outlined in this document you're about to receive, court rulings on what can be described as bad faith behavior of the medical board. This ruling of the document came out in April 17th of 2019 in the Dr. Morgan case, Madam Chair, who is one of your constituents. This dates back to 2013 when he was alleged to be operating a pill mill. This has been going on through district court cases, Fifth Circuit Court of Appeals, and this is the recent ruling where the District Court of Travis County reversed Dr. Morgan's final order. In it, if you'll see that the findings of facts is that first bullet point stated that there were ample evidence to suggest that the police either knew about or requested the search, finding that there were several contacts between the TMB and DPS with regard to using the information secured as a result of a subpoena to charge the defendant with a crime. There are 4 cases currently pending with the Fifth Circuit Court of Appeal where the medical board has come in with DPS agents, DEA agents, or law enforcement to come in heavy-handed through intimidation to force the surrender of patient records. There's no dispute that the TMB has the right to submit subpoenas, but they do not have the right to force them. And this is what's happened in this case as well as the other 4 cases at the Fifth Circuit Court of Appeal. What's also disturbing in that, if I hope that you will read these, because I have many instances of multiple physicians this has happened to since I've been researching this since 2016. I've been reading transcripts and depositions and have it from court cases, which are somewhat being ignored by the Texas Medical Board. In the case of the Dr. Robert Van Boven case, who was completely exonerated, they have refused to remove him from the National Practitioners Database. My information has been reviewed by Professor Ron Beal, who is the state-recognized administrator of administrative law. In his comments, he said he has reviewed Mrs. Hemphill's materials and positions as to all of her proposals for more meaningful oversight and sanctions for misconduct by the TMB board and officers. I would fully support those propositions. I have personally seen conduct by the staff that I believe is unethical that would constitute bad faith. There were recommendations for the TMB not to use law enforcement that were not in this bill, and numerous things that did not make it in the bill that would have helped with these things. Thank you.
Thank you for being here today, Ms. Hemphill. You said a lot of that and not taking a lot of pause for breath, so I know you got a lot of information. We appreciate the handout. Members, let it be shown that there are 7 witnesses registered but not testifying for the bill and 0 witnesses registered but not testifying against the bill. And yours is a part of the record as well. So we will leave this bill pending at this time. Thank you.